Hi, I'm going to give you an overview of the three cases that we're asked to focus on today. But to give you an overview of the cases, I need to first back up a little bit to talk about how we got here. Traditional state tort law and the current law in most states, as most of you will know, allows a manufacturer who's alleged to have sold a defective product to use compliance with federal standards as non-dispositive evidence that the product wasn't effective or that the manufacturer acted non-negligently. And in this way, traditional state tort law recognizes that federal approval and compliance with federal requirements has a role to play, and potentially a very powerful role, in products cases. So, for example, a typical jury instruction might say that FDA approval, though not dispositive, may be considered to show whether a product is safe or not safe. And sometimes the jury instructions are even stronger, giving the approval evidence even greater weight, such as in this pattern instruction from Kansas. If a product was at the time of manufacture in compliance with administrative regulatory safety standards relating to design or performance, the product is not defective by reason of design or performance unless the plaintiff proves that a reasonably prudent manufacturer could and would have taken additional precautions to design the product so as to be reasonably safe for the ordinary consumer. So over the past 20 years or so, manufacturers have argued that regulatory approval or regulatory compliance is not just a defense on the merits, not just evidence that the product was not defective or that the label was adequate, but a defense to being sued in the first place. Most recently, during the past 7 years or so, implied preemption has been the favorite defense of drug companies, food companies, automobile manufacturers, and others. And Wyeth, which we'll turn to in a minute, is an example of that trend. But in the 90s and continuing until a few years ago, the preemption cases focused more on express preemption provisions, and Riegel versus Medtronic falls into that category. The express preemption cases involve statutory provisions that clearly preempt, and the question in the cases is the scope of the statutory provision, and in particular for our purposes today, whether the statutory provision covers state damages claims. Riegel asked whether the express preemption provision of the 1976 Medical Device Amendments to the Food, Drug, and Cosmetic Act preempts state law claims seeking damages for injuries caused by medical devices that had come on the market by getting FDA approval. So, first, a brief background. The Medical Device Amendments enacted in 1976 was the first time that the FDA had authority to regulate medical devices. And in the meantime, some states had stepped in to regulate at the state level. So when drafting the medical device laws, Congress had to consider whether such state regulatory programs should continue to exist. California, for example, had a state pre-market approval process and state good manufacturing practices requirements that manufacturers had to comply with, since the federal government would now be covering those same topics. So to prevent a lot of differing requirements on the same topics, Congress crafted a preemption provision that preempts certain state law requirements with respect to a device that are different from or in addition to federal device requirements. In the late 80s and throughout the 90s, device manufacturers began to argue that this language preempted state common law claims. The Supreme Court first considered the scope of the language in a 1976 case, Medtronic versus Lohr, and held that there was no preemption of the state damages claims. The device there had not gone through pre-market approval to get on the market. In Riegel, the difference was the device at issue had gotten FDA approval. So the question was whether that made a difference. And in an 8-to-1 decision, the Supreme Court said, yes, the damages claims arising from injuries caused by devices that have been approved by FDA are expressly preempted. The court held that the language of the statute, which preempts certain state requirements, encompassed the state law duties on which a common law claim is based. So although many of the Supreme Court's preemption opinions start with the notion that the scope of preemption turns on congressional intent, I don't think any justice thought that Congress intended to wipe out state law damages claims, the sole means by which plaintiffs can seek compensation for injuries caused by defective devices. The legislative record from 1976 doesn't mention the idea, but as Justice Stevens notes in his concurrence, the case law had developed in such a way that by 2008, the language that Congress used in 1976 could credibly, or more than credibly, be said to apply to damages claims. Since this line of cases started to develop, Congress has not used similar language, the preemption of requirements, without adding a provision to make clear that it doesn't intend preemption of lawsuits. And bills are pending in both the House and the Senate to overturn the Riegel decision. Turning to implied preemption, after a decade or more of watching litigation over the scope of express preemption provisions, many of which held that there was no preemption, and having failed to push any bills through Congress to eliminate product liability suits, manufacturers started pressing an implied preemption theory. In the context of product liability law, the implied preemption doctrine asks whether the obligations imposed on manufacturers of federally regulated products by state common law are inconsistent with the federal regulation. The implied preemption theory essentially is that applicable federal regulation, whether a performance standard or a pre-market approval or a labeling approval, establishes both a floor and a ceiling for the regulated products. Automakers tried this approach concurrently with arguing about express preemption, and so the next case I'll turn to is Greier, which predated Riegel and raised both express and implied preemption theories. In Greier, the Supreme Court considered whether the National Motor Vehicle Safety Act preempted claims for injuries that were sustained in a car crash by a woman who was wearing her seatbelt, but whose 1987 Honda Accord was not equipped with an airbag. The Safety Act is implemented by the National Highway Traffic Safety Administration, NHTSA, and NHTSA's most important responsibility, and the one that's on which the preemption argument is founded, is the promulgation of federal motor vehicle safety standards. These standards usually take the form of minimum requirements for motor vehicles intended to decrease the likelihood of harm or to ameliorate the severity of harm in the case of an accident. NHTSA has promulgated safety standards for safety glass, door latch design, roof strength, and occupant crash protection. And of relevance here is Standard 208, occupant crash protection, which involves restraint systems like airbags, seat belts, shoulder harnesses. The 1984 version of this standard, applicable to vehicles such as Geier's 1987 Honda, didn't set one performance standard, but gave manufacturers a choice of 3 options, and compliance with any option met the standard. It also established a phase-in schedule for use of airbags and other passive restraints that gave manufacturers a period of time. They had to have more vehicles equipped each year with one of the passive restraint options till full 100% in September 1989. So that's the background. The Safety Act has an express preemption provision, and it also has a safety clause that says compliance with any motor vehicle safety standard doesn't exempt any person from common law liability. After Greier was injured and sued Honda, and the case made its way to the Supreme Court, the court unanimously rejected the express preemption argument in Greier. On implied preemption, which I think is what's most important about Greier, a 5-justice majority held that the claims were barred because Geier's damages claims would frustrate NHTSA's objectives with respect to Standard 208. The majority opinion relies heavily on the Federal Register commentary that accompanied issuance of the standard. The Federal Register notice did not discuss preemption. It talks about why NHTSA is formulating the performance standard the way it is. And the court says that allowing a range of options and a gradual phase-in is important to what NHTSA was trying to accomplish, and holding a manufacturer liable for not having an airbag at the time when the airbags were still being phased in would frustrate NHTSA's objectives. Our last case is Wyeth versus Levine, involves implied preemption in the context of a product liability claim against a manufacturer of a drug. Before 2002, drug companies seldom argued any sort of preemption. But soon after President Bush took office, the companies began to push implied preemption, originally in cases involving suicides associated with a particular type of antidepressant known as SSRIs. Most product liability cases about drugs are failure to warn cases based on inadequacies of the labeling, and the SSRI manufacturers focused their arguments on the particular history of FDA review of the labeling for that class of drugs. Their theory was that holding them liable for failing to comply with a state law duty to warn would be inconsistent with the FDA's review and approval of the labels of those drugs and the FDA's decision not to require a suicidality warning. Within a few years, the scope of the drug company's arguments had expanded to include almost any drug. So Wyeth, the story of Wyeth starts when Diana Levine went for treatment to a clinic for treatment of a migraine, and she was given 2 drugs, one for the pain and one for nausea. The nausea drug, Phenergan, was administered through an IV push method, which is a syringe directly into the vein. Unfortunately, the syringe either nicked the artery or somehow the drug came into contact with the arterial blood, which caused gangrene and amputation of her arm. Phenergan's label warned about the risk if the drug came into contact with arterial blood, but it didn't say anything in particular about the increased risk of using this IV push method as opposed to an intramuscular injection right into the muscle or through an IV drip. After her arm was amputated, Diana sued Wyeth, the drug's manufacturer, alleging failure to warn and strict liability. The jury returned a verdict for her. The Vermont Supreme Court affirmed, and the case went up to the Supreme Court. In a 6-3 decision, the Supreme Court also affirmed the no preemption ruling. First, the court considered Wyeth's argument that the claims were preempted because it would be impossible for the company to comply both with federal regulation and state common law. Noting that FDA regulations allow companies to revise their labels in light of information acquired after approval, the court rejected the impossibility theory. The court also rejected the argument that revising the label would have rendered the drug misbranded, and said the notion that the FDA would bring an enforcement action against a drug manufacturer for strengthening a warning was difficult to accept. Next, the court turned to Wyeth's theory that Diana's inadequate warning claim was preempted because the state law duties underlying it would obstruct the purposes or obstruct the goals of the federal regulatory scheme. The court rejected this theory as well, stating that it relies on an untenable interpretation of congressional intent and an overbroad view of an agency's power to preempt state law. The court disagreed with the notion that the federal law establishes both a floor and a ceiling for drug regulation, finding that all evidence of Congress's purposes is to the contrary. Aside from the very powerful rejection of conflict preemption, Wyeth is significant for the level of deference it gave, or rather didn't give, to the FDA. The FDA had stated in a preamble to a rule it issued in 2006 that there was very broad preemption of claims against drug manufacturers, and the court stated that this preamble does not merit any deference. The court noted that the FDA had stated when it issued the proposed rule that led to that 2006 final rule that the regulation would not preempt state law, and then had articulated a sweeping position in favor of preemption in the final rule, which the court said made the agency's views on preemption inherently suspect. The court said the preamble was at odds with the evidence we have of Congress's purposes and reverses the FDA's own long-standing position without a reasoned explanation. In strong language, the court said that the FDA's views did not merit Chevron deference and, in fact, were entitled to no weight. In dismissing the FDA's views, the court distinguished FDA's position in Wyeth from the agency's position in Greier. In Greier, the court had relied heavily on a Federal Register notice and preamble, but what the court had deferred to was not the agency's views on preemption. In fact, the Federal Register notice about the airbag rule hadn't discussed preemption at all, but rather discussed the substantive reasoning behind why the agency issued the rule, formulated the rule the way it did. In contrast, with regard to drug labeling, the agency's commentary had directly addressed preemption and suggested that Greier gave it authority to say not what the agency hoped to achieve by fashioning the regulation as it did, but what the effect of the standard would be on consumers' ability to sue. The government and the industry had both sought to use Geier's support for a general proposition the court should defer to the agency's views on preemption, and Wyeth rejected that approach. After Wyeth, defendants will likely try the broad frustration of purpose or obstacle preemption with considerably less frequency. Courts are already accepting the theory less often. As Wyeth recognizes, conflict preemption isn't a choice that the agency gets to make. It occurs where, as a matter of fact, an agency can't comply with both state and federal law, or where state law actually interferes with the operation of federal law. Preemption is also not about who should ultimately win the case, but whether the case can go forward. And whether an agency favors tort reform as a matter of policy should be largely irrelevant. That decision belongs to Congress.